Terrific. Welcome to the IP presentation, intellectual property presentation by David Postolski, ideally for the students in the pitch competition, but we've opened it up because of the virtual nature of where we are in the world to anybody in our ecosystem that can attend. And we're really grateful to see familiar faces and friendly faces. So thanks for joining us today. We're really lucky to have a great friend and partner to our Entrepreneurship Center program since its inception, David Postolski of Gerhardt Law, who specializes in IP law, trademarks, patents, and copyrights. I believe he's spoken to our students in every semester since the inception. And we're really lucky to have him here today. He's going to give us a wonderful presentation, answer questions that anybody might have, and ideally we'll be spotlighting some of the students that are joining us today with any questions to feature their projects. So you don't have to disclose the whole thing, but just giving maybe David a sense of where you're at so that he can tailor the presentation to your needs. All right, with all of that, I pass the torch to David to take it away.
Thank you, everyone. Good to see all of you. So sometimes if we were in person, it would be interactive. I'll try to make it as interactive as possible over Zoom. If you have questions, please chat them, maybe raise your hand. I'm going to share my screen. I'll put up some slides. You can have them after the presentation. You can, I guess you can email Jason or Elizabeth Rich, who's also on, see her name is Liz Rich. You can give them a quick email and they could share it with you as well.
Yeah, I'll send out to all the attendees a follow-up with the presentation.
Awesome, thank you. So as Jason said, right now I'm calling you from Tel Aviv, Israel, which is where I kind of split my time between West Orange, New Jersey, where I have a home, and Tel Aviv. I've been doing that for about 3 years. I've been an intellectual property attorney for almost 20 years, specializing in patents, trademarks, and copyrights, mostly in the field of startups, entrepreneurs, emerging companies. I started my career at very large law firms and kind of decided to give that life up and kind of devote my life to entrepreneurs and that journey. So it's a little bit of a different journey when you're working at a large law firm. So Gerhardt Law is a pretty small firm, and we're based in Summit, New Jersey. So we're right in your backyard for some of you. But I'm all about education and empowerment. That's, at the end of the day, that's what this presentation is all about, is to educate you and empower you about what is intellectual property, what are the process, how to get it, and some of the myths around it. So let's just begin. I'm going to share my screen. Hang on one second. I'm going to go into presentation mode, but I see all of you still. So if you want to raise your hands or whatever, you can. So I first just want to say, just really quickly, most people don't know this, but intellectual property is actually in the United States Constitution. This is right out of the Constitution, which was written like in 1790 of American history. So it's really old. It's really what the United States was built on in order for the United States to industrialize itself after the poor, the hungry, and the English came over to the States. They needed to make sure that this nation was going to go through an industrialization. So that meant that they needed people's ideas. They needed they needed inventors to share their discoveries. They needed authors to share their writings. And so we built into the Constitution what we call the Intellectual Property Clause. And this is what it is right in front of you. And it basically kind of signifies that this is a deal you make. Intellectual property is basically a deal. So you as a small company, you as an inventor, you as a writer, you as a brand owner, you as an entrepreneur, you as a big company, you have the right to share your ideas with the government, and in exchange, they will give you the right of property in your ideas that came from your intellect. And so That's what our nation was built on. That's how we get to the smartphone from, the regular rotary phone, or that's how we get to the LED light bulb from the regular light bulb. All of those were ideas that were shared with the government. In exchange, the owners of those ideas get a right of property. And so when you own a piece of property, you have amazing rights, because you get to control whether somebody comes into your property, whether somebody steals your property, where somebody copies your property, where somebody's doing something like your property. And so that's the basis of intellectual property. And so I put it in there just to let people know. We don't really teach this in high school, where we probably should be teaching it, but to let you know that the United States is one of the oldest living regimes of intellectual property laws. So if you understand how the United States does it, you'll definitely understand how every other country in the world does it, because they base their system on the way that we do it. Also, something just important, we're going to touch on it later, commerce. I don't know if you know what commerce is the buying and selling of goods and services. And so that's also a nod and a form of intellectual property that's related to trademarks. So when we talk about inventors and discoveries, we're talking about patents, which is one form of intellectual property. When we talk about, these are the forms. When we talk about commerce, we're talking about trademarks, because the government has the right to say, well, if you're going to buy and sell a good or a service, then you have the right to call it something. You have the right to call it Google, or you have the right to call it Nike. And so that's really important. When we talk about authors and actual writings, we're talking about copyrights, which are the artistic creations that you could protect. In the end, intellectual property is what we call the physical embodiment of intellectual efforts. An idea is not protectable. You must take the idea out of your head and actually physically embody it in something like a patent or a trademark or a copyright. So you have an idea for how something works or how something looks. You have an idea for a brand or a logo. You have an idea for a song or an audio visual work or something else artistic. You must actually take that out of your head and physically embody it in something, usually a technical description, the actual drawing of the logo, the actual song written on a piece of paper, and then you file that through someone like me with the United States Patent and Trademark Office or the United States Copyright Office. And if it's awarded to you, you get the exclusive monopoly to control what it is that you created. So we're gonna go into all the different forms of intellectual property. Each of them are very unique. Each of them have different processes and costs and timelines and rules, and we're going to talk about them at a 30,000 foot view, and happy to discuss details if you have any questions after the presentation or even after this whole session. But I think the biggest thing to realize is that, if you're sitting on your couch and you have a great idea for something and you're watching somebody else pitch the idea on Shark Tank, then you probably were a little bit too late, right? In the end, you probably should have taken that idea and done something with it, because if it's already pictured on Shark Tank, then likely somebody has not only had a similar idea to you, but also sought to protect it first than you. So keep that in mind. But it is a choice. It is a choice you make as an entrepreneur, as a startup, as a company, to actually get a patent, the first form of intellectual property. There are three companies pictured here. I don't know if any of you know what these companies have in common. Any of you know? There's Google, Kentucky Fried Chicken, Coca-Cola. These companies have patents. Well, Google has some patents, but what do they have in common? Anybody know? Anybody want to get off mic and say what they have in common? Obviously, they have trademarks. That's not what I'm trying to get at, but they have something else in common. And if basically it's what we call a trade secret. So, Google does not have a patent on their search algorithm that they created 25 years ago. So every time you search Google, it ranks the search results. And so they don't have a patent on that. Coca-Cola does not have a patent on their formula. KFC does not have a patent on their recipe. That's what I said before. You as a company have the choice. You have a choice to make, whether you want to patent something or whether you want to trade secret something. Those are two, or whether you want to keep something trade secret. Those are two completely opposites. A patent is the most public expression of what you have created. A trade secret is the most private expression of what you created. But if you want to take the intellectual property deal that I mentioned before and actually go down the path of getting and securing a patent and making it public and explaining it to the patent office and being awarded a patent and exclusive monopoly for 20 years, then the deal you get is that it is your monopoly for 20 years and that you get to control whether somebody can do something similar to you. That's worth a lot in this world, right? The ability to stop someone from doing what you're doing, from making what you're making, from creating what you're creating, from selling what you're selling. In order to do that, you need to spill your guts with what your idea is. The only way the government's going to award you a monopoly on an idea is if you took it out of your head, put it in a patent document, put it in a technical document, described how it functions and works and its structure and features, or how it's designed, and then be awarded a patent. But a trade secret doesn't have that, right? You can keep something trade secret longer than 20 years. A patent lasts 20 years. You can keep something trade secret for 20 years. But what you can't do with a trade secret is accuse someone of infringement, right? That someone's copying you, that someone's coming into your property. You don't get that right with a trade secret. The only right you get is if somebody misappropriates it from you. They basically steal it from you. If there is no evidence of somebody stealing your trade secret from you, then there's nothing you can do as a company if you believe that somebody is doing what you're doing, right? If somebody has reverse engineered what your trade secret is, and there's no evidence of them stealing it, then there's nothing you can do to them, right? That's why Google can't do anything to any other search algorithm site that there is. That's why Coca-Cola cannot stop Pepsi from creating a similar, tasting drink, right? They don't have the patents. They don't have the ability to go into a court or threaten to go into a court and say, this is my protected patent. This is the blueprint by which I do it. And we believe that whatever you're doing is falling within the definition of what we have been granted a patent. Without that, with a trade secret, there's nothing there. You're not registering anything. You're not applying for anything. You're not being awarded anything. Don't get me wrong, it's great. You're keeping something secret and it could be valuable and it could last. There's a lot of benefits to it. It can last longer than 20 years, for sure. But the biggest thing about intellectual property, I think all of you need to understand, is that patents, trademarks, copyrights, they give you the right to stop others. That's what it's all about. It's the power of exclusion. And so it comes with a price, comes with definitely a price. You have to, hire a patent attorney, hire a trademark attorney, hire a copyright attorney, and you have to also enforce your patents and trademarks and copyrights against people. But it's a little bit easier to do when you've been awarded the patent. You've basically proved what you've had to prove. You basically prove what you had to prove to get a trademark. You prove what you had to prove to a copyright. And if you believe someone's infringing you, then the person you believe is infringing you, they have to prove that they're not infringing you. You've already proven to the patent office, to the trademark office, that what you've created is truly unique and novel and distinct. And so the burden shifts to the person you believe is infringing you to prove that they're not. That's the money right there. That's why patents are so popular in this world. And there's a few other reasons that we'll get to. But in the end, it's your choice. Keep something trade secret, keep something patent. It's definitely a choice that every company has to make. You can't really get the best of both, but there are kind of strategic ways to do that. So keep that in mind. Couple things about patents that you should know. There's two types of patents in this world. Design, right? There's the Coca-Cola bottle design. So if you have a unique design for a product or a computer graphic or packaging or something where you want to protect the ornamental features, the look and the feel, as we say, design, jewelry, furniture, stuff like that, you can file for a design patent. Again, your design has to be novel, has to be new. But if it is, then you can get 15-year protection on that design. It's great, great, great protection. If you think about Apple, They have, you know, multiple patents on how their phones look. Every version of every phone they have multiple designs on how the phone looks, not how the phone works, but how the phone looks. But the most popular type of patent is what we call a utility patent. It's how something works. It's its features, its functions, its structure. And so it's usually a process, software, machine, manufacturer. It's something based in science usually. So my background as a patent attorney is in computer science and chemistry. Most patent attorneys, all patent attorneys, have a science background so that we could technically describe the inventions of our clients in a way that convinces the patent office that what they've created, what they've invented is truly unique and novel and never been seen before. So most patents, most utility patents fall within the sciences: chemistry, physics, biomechanics, electrics, computer science, geology, botany, any sort of science. So that's, it needs to be that hook in order to get a utility patent. You can get a patent on a method, but it usually has to be tied to something else like software or something like that, or a physical device or something like that, or an apparatus or something like that. But yeah, utility patents are to protect how it works. Apple, back to Apple again, they have hundreds of patents on how the iPhone works, how the Apple phone works. Patents on how it looks, patents on how it works. Both of them are equally important, depends on what your product or service is, right? If you have a unique design, you probably want design. If you have a unique utility, you probably want utility. Most people file for both because if you want to claim infringement of both, then you need both. Right? You can't use your utility patent to claim infringement for a design, and you can't use your design patent to claim infringement of a utility. You need both. And so there are there are kind of strategies on how to file, and we'll get into it when you see the word provisional. We'll talk about it in a second. It's a very important part to the journey of an entrepreneur. These are kind of the top reasons why you get a patent, why you get any intellectual property at the end of the day. It's property. Right? Property is valuable. If you own a home, you get to do a lot with your home. You can use your home for a line of credit, right? We use patents for investment, kind of the same thing, right? You pitch to an investor and the investor knows that you have something awesome through your intellectual property, and they're going to give you money, right? So they're going to invest in you and the company, and they're going to invest in your most number one asset, which is your intellectual property, which is your patent and trademark. So patents are great in terms of collateral for loans. It's property, so you could sell it, you can lease it, right? Leasing in the world of intellectual property is what we call licensing. So you can use that patent to license out, the manufacturing process, or you can license your patent to a company that, and then kind of collect a royalty. So they'll make it for you, they'll sell it for you, and they'll give you a royalty if they do. That's like the holy grail of intellectual property. But in the end, I think the biggest reason why anybody should get intellectual property is the fifth one. It's the right to exclude someone else from making, selling, offering to sell, or importing your patent. Make no mistake about it, the only way in the world to stop someone from doing what you're doing, from making what you're making, from creating what you're creating, is through the registered intellectual property. There's just no other way. That's value for sure. You don't have to, right? You don't have to get the patent. You don't have to get the trademark. You don't have to get the copyright. You can continue doing business. You can market yourself, but you won't be able to stop a competitor. You won't be able to stop someone that's kind of needling in on your business or, affecting your bottom line. So it's great protection. And, but in the end, let me just see if, can I get a patent for a trade show? No. I just saw the question pop up very quickly. And the reason is kind of what I said before. A patent has to be based in some sort of science, right? It has to have the science hook, right? So business, like a trade show, if that would be like a business method, it has to be tied to some software, some computer technology. So could it be a virtual trade show in today's world? 100%. So if your computer science software programming behind your virtual trade show is novel and new, then yeah, you can possibly get a patent on that. but most likely the way to protect a trade show is probably by the name, the trademark, which we'll get to in a second.
David, there's
Very
another question in
important.
the chat there from Judy. What about social science?
So it depends. That's a good question, Judy. You know, I have some, I'll give you an example. I have some clients that do some social science. They have so again, it's back to software. That's the reason why I can give this example. They basically use software to administer a service based in social science, right? So yes, it's possible, but social science on its own, no, right? It needs to. There are some sciences that don't per se, but like as an example, like I have a client that also does like psychiatry and like psychology, just science in a way, right? The sciences, but they do it through computer science. That's the whole thing. So so I'm happy to talk about that probably more. I need to know exactly what type of social science and how you're delivering the service. But theoretically, yes, you could get a patent on a social science if it was tied to software. Okay, great. Thank you, Judy. Most important thing you're going to probably learn about patents is this, very important, and mostly for everybody on the call, but definitely for the students involved on this call. So it used to be the United States. We're almost coming on the 10-year anniversary. It's crazy. We used to be the only country in the world since 1790 up until March 16, 2013, to be what was called the first to invent country. What does that mean? It means that if I invented something 10 years ago and I never filed for my patent, I had no money, I didn't want to, I was tinkering in my garage, and Jason invented the same thing 5 years later. So I invented 10 years ago, he invented 5 years ago. I live in California, Jason lives in New Jersey. We don't know each other. There's no evidence that we know each other. Just two independent entrepreneurs who come up with the same idea. Happens all the time, right? So I invent 10 years ago, I don't file my patent. Jason invents 5 years later, but he does file his patent. We were the only country in the world for over 200 years that says that I can say, hey, what about me, right? I didn't file my patent, but I invented this 5 years before Jason. I should be the rightful inventor. And that's exactly how it was. Whatever Jason filed would be invalidated and I would get the superior right because I was the first to invent and I could prove it. And that's how it was for a long time, until President Obama signs the America Invents Act, and it basically changed the face of everything. We are now like every other country in the world. Same situation. I invent 10 years ago, Jason invents 5 years later, and he files his patent first. He is the first inventor to file his patent. Jason will win that contest. I can no longer jump up and down and say, hey, what about me? I took too long. It is a race to the patent office. Whoever files first will ultimately, the first inventor to file first is the person that will have the superior right. So when you have a really great idea in today's world, you really got to keep it close to your vest. You really cannot make it public. You really need to file a patent application first, right? And then you can speak about it, because if you talk about it to everyone and somebody hears it, or my friend told your sister, told her brother, and he filed the patent application first, he may not have been the first inventor, but he definitely will be on file before you in this hypothetical, and you would never be able to prove that chain of command, that chain of title that we just talked about. And so you would be, out of luck, basically. So really important. It's a race to the patent office. If you have a great idea, you must file a patent application first. And to go back to that original slide that we talked about, that's what a provisional patent is all about. The United States has a way for you to file a patent application quick and dirty, as we call it, right? Get something on file. No, get a filing date, get an invention date. Then you can talk about it. Then you can do whatever you want. The provisional will allow you a year to really update that application with whatever you need to add to it, right? Because some people don't know how it's going to work, or they think they know how it's going to work, or they have a sense of how it's going to work, but they need more research, they need more development, they need to go into the lab, they need to work with a mechanical engineer. Great, you can do all that. But if you take 3 years to do that and then file your patent application, well, your invention date is 3 years from now, and somebody could have easily filed before you. So file now, right? File a provisional now, right? And then have a year. Yeah, you'll have a timeline for sure, which is a good thing for an entrepreneur, but you'll have a timeline to really update the application with everything that you will learn, that you should have learned, and put it into the application. And so it becomes, then it matures into the type of patent application that will be examined and awarded to you as a patent. So yeah, I think this is an important concept for all of you to learn. So if you learn anything, it's this, that you shouldn't be talking about your ideas publicly, because the moment it's public, the clock on you filing a patent application has started. Most people don't realize that. I have so if you've made a public disclosure, as we call it, which is basically telling anyone that is not under an NDA. And the moment you're telling your idea to anyone not under an NDA, it's considered public. The moment it's considered public, you only have 1 year under this new law, it's called a grace period, to file a patent application, right? The government's not going to give you 10 years, like in that hypothetical, they're not going to give you 10 years to file for a patent. They'll give you 1 from a public disclosure. And if you don't file within that 1 year, you will lose the right to call yourself the inventor of that invention. So you really should not do anything public until you at least have something on file with the patent office, or have a non-disclosure and everything's locked down, meaning the public clock has not started against you. And this includes selling your product, right? I have a client that came in and he was like, oh, I've been selling my product for 2 years and now I want to file a patent now. Well, sorry, you're a year too late, right? You're like a sale is public. So you're a year too late and we can't do anything for you. I definitely have clients that like come in and it's unbelievable when one of the first few questions we say to them is, who have you told? Right? Tell me everybody you've told. Okay, I've told this one, that one, this one. Okay, give me the dates of all those people and tell me how many of those people have a non-disclosure. And usually it's none. Nobody knows to do this. This is not something we teach in schools. It's a big problem. And when we create the timeline of like who they've told, I've been in situations where we have 3 days, 3 freaking days to file for a patent application because the year is upon us. So either we're going to file in 3 days or they're going to go back to everyone they told, right, and get them to sign a non-disclosure agreement. So who even wants to be in that world, right? The best thing to do is use non-disclosures or file for patent applications. So that's really important. Hold on. Okay, I was just looking to see if there were questions. Because I kind of want to get away from patents in a minute, but I see a question and it's a good one. How long does the patent registration take and how soon are you protected once you start the registration process? Excellent question. Okay, so I think I even have it on a slide. No, I don't, but I'll talk about it. Okay, so a patent application. So there's a few, I kind of mentioned a lot of different things. So we'll kind of put it like in a hypothetical. So let's say I make a public disclosure of my idea on March 1st, 2021. To public disclosure, I didn't file my patent application. I have until March 1st, 2022 to file a patent application. If on March 1st, 2022, I file a provisional patent application because I'm not ready yet, I'm still kind of figuring out what I need to do, and I file that on March 1st, 2022, I will have until March 1st, 2023, right? I get another year to figure out how my invention actually works and supplement the provisional application with an application called a non-provisional application, right? So Now I have this non-provisional on March 1st, 2023. 18 months later, that's how long it takes the government 18 months to look at your application. They will examine your application. They will basically do a search of all the other patents in the world, which is why sometimes we recommend we do a search for you when we file a patent application so that we can anticipate what the government's going to find. So it kind of, sets you up for, for success. So in this hypothetical, 18 months from March 2023, your patent will be examined. It will take about 2 years examination. So, in all, from beginning to end, a patent application could take anywhere from 3 to 5 years, once, depending if you kind of follow this scenario. And it will cost somewhere around $12,000 to $14,000 over that period of time, all that time. And it will last for 20 years. This is the beauty of it. It will last from 20 years from your original filing. So in that hypothetical, it was your provisional, right? You had that 1 year public, then you have your provisional. So it'll be 20 years from that date. Patent is not renewable. It expires after 20 years. But yeah, so that's, and that, by the way, everything I just said is the United States. There's a very limited time for you to take your US patent and your US trademark, for that matter, we'll talk about that in a second, and file internationally. Most companies in the world, most entrepreneurs, most startups, they basically give up this right. It's too expensive for them, right? I mean, if you're spending $13,000 to $14,000 in the US alone, you're probably going to spend at least that much in every other country that you want to file in. So most of my clients will file in very strategic countries. Maybe they know that they're manufacturing in China, so they're going to file in China. They know that they know that they're going to have a market in Europe, so they're going to file in Europe, right? You want to file the patent in the country where you want protection. You don't need the patent to market or sell in that country. But if you want the ability to go into a European court to stop a European infringer, or go into a Chinese court to stop a Chinese infringer, you can only do that with a Chinese patent, with a European patent. You cannot do that with a US patent. So you have a very limited time, and it's pretty limited from the provisional, like going back to that hypothetical where you filed a provisional on March 1st, 2022, you will have until March 1st, 2023, which is also the time that you're going to convert the provisional to a non-provisional. That's also the time for you to start the international patent process. If you don't start the international patent process, then you do not have the right to get into these countries that you may want protection in. It sucks. It's just the way it is. I mean, that's just the system that we live in. It basically was a treaty that was signed in 1970 called the Patent Cooperation Treaty that said like most of the countries, about 153 countries, there's about 35 countries that are not in it or something like that, maybe even less these days. And they all said, we're going to abide by the same patent laws. But in order for us to do that, you need to meet these deadlines. And so, yeah, most people give up international protection. It's sad, but it's just a kind of reality of what's going on. Most people, there's a great question here from someone that says, why start in the United States? I do a lot of work overseas. I do a lot of incoming US work. So I'm helping US entrepreneurs and startups file their US patents or their US trademarks, but also helping them in other countries as well, right? To kind of, file in Europe, file in China. But I also help Chinese, European, Israeli, South African companies file in the United States in the first instance, right? They're not even filing in their own countries. They're filing in the United States. And why is that? Whether you believe it or not, whether you're living it or not, the United States is the gold standard, is the gold market. This is the market that everybody wants to play in. So if you want to play in this market, then you need the patent and trademark in this market. And so if you're not playing in your home country's market, you're a country that exports, like you're a country that doesn't really have a market of its own and has to concentrate on another market, well, that's the market that you need to file and protect in. So another thing is the United States highly, highly respects, I mean, we've been around since 1790, our laws, they highly, highly respect the intellectual property rights of a business owner, right? Our courts respect it. There's fairness and justice here. That's a big thing. That's what makes the United States such an attractive country to file their intellectual property in. And sometimes, you know, some other countries may have great markets, but don't really respect the international, the international rights of the intellectual property rights of an international and foreign rights holder. So there are huge offenders of that. But in the end, the United States is definitely the gold standard, and kind of why I focus the presentation on the United States, because if you understand how we do it, you'll understand how everybody else does it. In the end, whatever you're going to protect in the United States has to be novel, right? It has to be new. And so it's important that you achieve that first step first. And the way to do that is to do a patent search and to really do it with a patent attorney who can give you an opinion on what exactly are you getting protection on? Is it worth it, right? Is it going to be really broad? Is it going to be really broad protection or really limiting protection? Could be, limiting protection could be great protection. What I'm trying to say is I'm not advocating for patents per se. I'm advocating for understanding what is the value add that you're bringing, right? What is it? What's the industry you're playing in? Is it patent heavy? Is it not patent heavy? What is your goal? Is it investment? Maybe you want the patents. Is it to exit quick out? Maybe you don't need the patents. Is it something? Is it science related? You definitely need the patent. So there's certain industries that love it, certain industries that don't care for it, but then ultimately it's your choice and kind of what you want to do with your business. So that's patents. Any final questions on patents before I move to really fun stuff? Trademarks. Actually, I think I have, trademarks. Any final questions on patents? And again, we can talk after this session. You can email me or what, but, and again, I teach a whole course on patents that takes 35 hours of time for potential law students and students. So this is like the tip of the iceberg, but enough, I think, for you to kind of make an informed decision as to whether this is something you want to do. Okay. If you're not going to file for a patent, and it's okay, most people make the decision not to for various reasons. Everybody wants commerce. I don't care what business you're in, you want commerce, which means you want a trademark. If you are going to be buying and selling a good or a service in the United States, then you must have a trademark. You must have the ability to stop someone else from using the same word as you, the same phrase as you, the same logo as you, the same colors as you, same sounds as you. Trademarks appeal to the 5 senses of a consumer. The moment you hear the MGM Lion, you know that is a movie studio, and the service they're providing is creating audio and visual works for entertainment purposes. The moment you walk into Abercrombie and Fitch, you know that smell, and that smell signifies that they are a clothing store. The moment you see the actual, I'll pick any one of these. The moment you see the Coca-Cola script Coca-Cola, you know that they sell soft drinks, right? So a trademark is a brand identifier. The moment you see, smell, hear it, you know what it is. And all of those things are protectable. And the only way that you can get a trademark in the United States is if you have what is called interstate commerce. You need to be able to have at least one customer in one other state. So if you're just a New Jersey business with New Jersey marketing and New Jersey customers, then you only qualify for a New Jersey state trademark, which means that you can only stop other New Jersey businesses from using the same trademark as you. If you discover that somebody in Wisconsin is using a similar trademark to you, then no, you cannot take your New Jersey trademark and potentially sue them for infringement, or ask, or send them a cease and desist letter saying, I have a New Jersey trademark, I see what you're doing in Wisconsin. Sorry, you can't do that with a state trademark. But if you were a New Jersey business that marketed to another state, that sold goods and services to another customer in another state, then that is interstate commerce. That qualifies you to get a federal trademark that covers all 50 states. So if you have at least one customer in one other state and you're able to prove that, you can qualify yourself for a federal trademark, and then you're able to stop someone in any other state. It's a powerful tool for sure. We also live in a country that is based on common law, right? Where the whole thing about the Constitution, where the English came here. And so a lot of our laws are based on English common law. And one of the English common laws that we have relates to trademarks. So there are ways to use a trademark that is unregistered. So like, I'm using my trademark. I have a website, I have customers in other states, maybe I have customers in 3 states, but I haven't filed for my trademark registration yet. I haven't done my federal trademark registration yet. Okay, you have certain rights. They're called common law rights. They're limited for sure, but you have them. The problem is like a trademark, like patents, is what we call first to file, right? I said before, the first inventor to file wins in patents. In trademarks too, if you can file your trademark first, your federal trademark first, then you may have the superior right over someone that didn't file their trademark first and has been what we call has been using your common law trademark. They haven't filed yet for whatever reason. You may have the right then, you'll get the federal right that might trump the common law right that someone has. And so I've been involved in situations like that. It sucks for the customer, right? It sucks for the person that's been using their trademark for 10 years. And then along comes someone who's only been using it for 2 years, but has filed their federal trademark first. And now they're trying to stop the person that's already been using it for 10 years. That's the world we live in. So in trademarks, we say the same thing in patents. File fast, right? Get on file as quickly as you can. And some people say, but I'm not using it yet. I have a great idea for a trademark, but I'm not really selling anything yet. You told me I have to sell. I have to have a customer in another state. I got to sell goods and services across state lines. I'm not there yet. So what do? I have a great idea for a trademark and I'm only going to sell in 3 years. But if I file in 3 years, that means someone else can file before me. What do I do? And so the United States has created an amazing system, unlike most in the world. There's only very few countries that do this, like 2 or 3 countries other than the United States that do it. It's called an intent to use application. You can, even though you're not selling your goods and services yet, you can file for a trademark today. It could be examined by the trademark office. It could be awarded to you. And I'm going to talk about how you create a good trademark, how you get a good trademark, how you get it awarded to you. My point is you file, it gets examined, and the trademark office basically says, we're allowing it to, it's called allowance. We're allowing you this trademark. And from this point on, you will have 3 years to start using it in goods and services, right? That's when you have to prove use, but it's yours. You have your filing date. If somebody comes along and files after you, you're good because you predated them. So we don't want you to wait. We want you to file for your trademarks, even if you are not using them, and you will have about 3 to 4 years to really start using it. And between us, if you can't start using your trademark in 3 to 4 years, then I don't know, that's bad planning and not a good thing, right? That's not a good, I definitely have clients after 3, where it's like been 3 years and they're not using it yet. We got to refile it all over again. So, you know, there's some planning that goes into kind of when exactly do you file for a trademark that should be contemporaneous with your plans on when you're actually going to start selling the product or service that you said that you're going to sell. So keep that in mind. Trademarks, like patents, are what we call territorial. I'm going to get to that question, Nick the Brit, in a second. It's a good one. But trademarks are territorial. It's like a patent. If you only have a trademark in the United States, your protection is just in the United States. If you want protection of your trademark and you want the ability to stop another company in Canada, then you need the Canadian trademark to get into the Canadian court to stop the Canadian company that's potentially using a similar trademark to you. And you'll have a very limited, actually, you have a limited time, but you have a lot of time. Let me explain. If you file for your trademark in the United States on March 1st, 2020, you will have 6 months to file in another country. And the beauty of filing within another country within 6 months, what's 6 months from March, April, May, June, July, August, September, right? September. If you can file by September 1st, 2021, 6 months in this hypothetical from your US trademark, if you can file in 6 months in Canada, then your filing date in Canada is the March 1st, 2021 date of your US application. That could mean all the world of difference, right? When we're in a world of first to file, who files first? The earliest filing date wins. So being able to gain 6 months in another country is very valuable. But let's say you don't do that. Let's say you don't have the money to file within 6 months. It happens all the time. I can't think about that yet, right? I can't even think about filing in another country. Let me just think about the United States. And 3 years you come to me on March 1st, 2024, you come to me and say, now I want to take my US application, my US registration, and now I want to file it in Canada. You can, great. But the filing date in that country will be March 2024. You will not get, the protection. You won't get grandfathered in based on your US application. So again, it's a big decision as to when you start the application, because the 6 months will start from that time. So the question from
David, before you transition to the question, just if you could put a bow on trademarks, can you gave an estimate of patents? Can you give an estimate of trademarks?
Yes, and I'm totally not done with trademarks, but yes, good idea. So a trademark will take about a year to get if you're using the mark, right? Because that happens too. I have a client will say, I started selling the product a month ago. Let's file the trademark now. Great. That'd be quick. We can get it in 8 to 12 months. If you're not using the mark in that hypothetical that I told you where you file as intent to use, it could take as long as 4 years. And the cost could be anywhere from $2,000 for that year, like over that year, and the trademark will last 10 years, and then it will be renewable by 10 years. It's the only intellectual property that's renewable. So for $2,000, you can get a trademark within a year, and then you'll have it for 10 years. And then every 10 years, you'll renew it probably for another $2,000 and in perpetuity, like Coca-Cola has their trademark for over 100 years. If you're not using it, it could be a little more expensive. It can maybe over those 4 years, you can spend $4,000. Just keep that in mind. So there is a cost to not using it. Meaning if you're filing as intent to use and eventually have to prove the use, there is a slight additional cost. So yeah, that's trademarks last 10 years around the world. Everybody, it usually is 10 years and it's renewable every 10 years. And it's renewable only if you can prove to the trademark office that you're still using it in the same way that you're using it. Every trademark is filed in a class, we call it, a class of goods or services. So if you're selling clothing, you're in class 25, as an example. If you're selling paint, you're in class 1. You're selling educational services or software as a service, you're in class 42. Every class has an official fee attached to it. So every class is $350. That's what the government charges you. What I was giving you was kind of some of the legal fees, but there's also official fees involved. And so the classes are important because if you told the trademark office that you were selling clothing and 5 years from now you're not selling clothing, or maybe you're still selling clothing, but you're also selling, phone cases, then that's an issue. One, the trademark office is not going to, you don't have protection for phone cases, so you probably need a new application there. But if you stop selling if you stop selling clothing and now you're only selling phone cases, then when you provide the proof to the trademark office that you're using the trademark, but it's not on clothing, but it's on phone cases, they're not going to renew it. So you really have to think long and hard about what are the goods and services that your trademark application will cover, because that's what you want to file the trademark on. And you can add classes by filing new applications. So keep that in mind as well. So you can definitely go into different verticals, and you just have to file a new trademark application in that particular class. So how do you get a trademark? And I think it will answer some of the questions that I saw. So I'm not going to answer them directly, but I think these next six or seven basic rules on how to get a trademark that everybody needs to know. So it's called the United States Patent and Trademark Office for a reason. You're basically filing for a patent. The patent will be examined. The examination will consist of a patent professional that works for the patent office that will basically do a worldwide search to determine whether your invention is novel, which is why we do a search. And if your invention is novel and your patent attorney could convince the patent office of the novelty of your invention, you will be awarded a patent. It's a very similar process in trademarks. We do a search first to see whether there are other marks out there. I'll get to that in a second. And then once we file an application, your application is assigned to a trademark attorney. The trademark attorney will do an examination, meaning they will do a search of other US only marks, right? It's not a worldwide system. It's a US only system for trademarks. And then if your mark passes examination, which we're going to talk about in a second, you will be awarded a trademark for 10 years. But one of the basic tenets in trademarks is that your mark, whatever you're proposing to protect, should not conflict with another already existing mark that is already on file with the trademark office. So if you want to file a trademark for Nike, you are all and you don't want to sell sneakers, you want to sell glasses, that's fine. But you're already starting behind the 8 ball. Already the trademark office will likely cite Nike sneakers against you. And you will then have the additional duty to prove to the trademark office during the examination that your Nike glasses, since it conflicts with Nike sneakers, is not confusingly similar. It will be your duty to prove that your mark is not confusingly similar to the Nike that's already on there. And you might say to yourself, but I'm selling glasses and they're selling sneakers. Yeah, that's great, but the marks are identical, right? They're the exact same thing. The trademark office is there to protect the consumer, right? They don't want to give you another word that might be similar to another brand that's out there, and the consumer is going to be all confused. They might think that Nike is now making glasses, right? And so they're trying to protect the consumer. They're trying to protect Nike from that because they're already on file, but they're also trying to protect the consumer from like having mischaracterizations of what Nike actually does and sell. So conflicting marks, you can try for it, but why not come up with what we call a distinctive mark, right? And so we'll get to what distinctive means. But another thing I want people to realize is I definitely have a lot of clients or potential clients that will come in and say, well, I have a great idea for a trademark. I went to the trademark office website, I did my own search, and I did not find an exact match. Great. That is just step one. A conflicting mark is not just an exact match. It's not just Nike versus Nike. It's also confusingly similar marks. So let's say I want to create a brand called Pikey, P-I-K-E. Maybe it's even Pike, but it looks like Nike, right? Pikey, right? And so I want to sell glasses. So again, can the trademark office decide that your trademark Pikey is confusingly similar or in look, in sound, in whatever to Nike? 100%. So when we do a trademark search, we are looking for words that have one letter differences, words that rhyme with it, spelled the same, look kind of similar, have a similar logo. We're looking for the potential for confusion, the likelihood of confusion. That's what the test is. Not just conflicting marks, similar marks. That's the number one thing. And so that's why you want to do a search. But ultimately, though, the way to get around this is to create what we call a distinctive mark, something that really stands out, something that nobody has ever seen before, something that nobody's ever heard before, a logo that's never been designed before. I get it. It's hard. It's definitely hard. Not as hard as everybody thinks, but it's hard. So these are the 5, what we call they're basically legal, kind of legal definitions. Every trademark gets assigned one of these 5 distinctive categories, from generic to fanciful. Those 5 things, every trademark that's filed will get one of these labels. And so we'll start with what the worst labels to get, which is what we call generic, right? So if your trademark uses a generic term, it will not achieve protection. The trademark office is all about giving the exclusive right to somebody, the exclusive monopoly to a piece of property, i.e. a trademark that is only yours. So the trademark office is not going to give any one company the right to control a generic word like hotels, right? Hotels.com did not create that word, right? It's a word they took, and it's generic. It belongs to everyone. So they can use it, but they're not going to be able to stop anyone else from using the word hotels. So using a generic word definitely comes with risk. But oftentimes when a company or an entrepreneur wants to use a generic word, we usually say you're going to probably need to add a logo. That's why logos are so important. So hotels.com has a filing with the 2 arrows, that they have protection with the 2 arrows over the O and a red background. That's really their protection. They basically had to disclaim exclusive use and protection of the word hotels. But it's a choice you make as a company. Do I want the generic word? It kind of, describes what I'm doing. So yes, I won't be able to stop anyone from doing it, but I want it, and I'll add a logo. Fine, great, as long as you understand the risks. But, we often say, better to have a trademark that you can enforce against others, that you can stop others, right? Because if you're like if you're like the 500th company that's using the word hotel, there's probably going to be 500 more after you. So where are you actually sticking out? Where are you sticking out in SEO? Where are you sticking out on Google, right? On their search algorithm? Like how are you going to stand out? So it's going to cost a lot of money to stand out. So keep that in mind. Second worst type of trademark is what we call descriptive, right? If you have to basically explain what you are doing. Here's a company called Aqua Leak Detection. There is no way in hell this company can describe what they're doing without using the words aqua and leak and detection. There's no way. There's no other way they can do it, right? They don't fix glasses. They detect water leaks, right? So if you, as a general rule, if you have to describe your goods or services that you're selling by using the name of the trademark, then the trademark will be deemed descriptive, and the trademark office will say it's not functioning as a trademark. It is descriptive. We will not give you exclusive protection over it. You will have to disclaim use of those words. That is not that's the opposite of what trademarks are about. We don't want you to be descriptive. We want you to be distinctive. And we'll get to what those are in a second. So what does Aqua Leak Detection have to do? Similar to what hotels.com has to do, they have to add a logo. Again, it's a company's choice. We want it. We want Aqua Leak Detection. We want everybody to know exactly what we're doing, right? We just want to this is what we're doing. We don't have to explain it. It doesn't take any effort. Between me and you, very low creativity there, right? I mean, much better to come up with a creative brand where you have to teach the consumer as to what you're doing. You'll only benefit from it later. They have protection for their scuba diver. Great. Here are the 3 best types of trademarks. The first one is Airbus, right? Airbus is what we call suggestive, because a consumer, and for those of you who know Airbus, great, but for those of you who don't know, it's a plane company, and a plane doesn't fly in the air, and a plane is not a bus. So they've taken 2 generic words and they put them together in a way that a consumer has to kind of ask, figure it out. What do they do exactly? That's already starting to be on the level of distinctiveness that we're looking for. So being suggestive is great. When a consumer has to ask what you're doing, that's you're on the road to what we call distinctiveness. there is, it's not the best. It's the third best type of trademark. It has its issues. It's very close to descriptive, right? A plane is not a bus, but they both carry people. So suggestive marks are great, but you have to be a little bit careful of them as well. The second best type of trademark is what we call arbitrary. So usually I ask people at this point, I'll usually kind of say the word Apple and usually ask people what they think. And there's usually one or two in the audience that think of, apples. But most people nowadays, when they think of Apple, they think of the consumer electronics company and all the products that they make. And so Apple is Apple is a generic word, but the way that Apple is using it is not descriptive. It is arbitrary. They've created a new meaning for it. Apple doesn't sell apples, right? They sell, computers and iPods and stuff like that. So this is great if you can do this. And this kind of goes against some of the consumerism that we kind of think people are expecting. Like you basically teaching the world what your trademark means. Right now, Apple's become synonymous with electronic products, so they've taken it above and beyond the actual fruit. That takes massive marketing dollars for sure. But in the end, it gives Apple enormous protection. So keep that in mind. And then the best, the most distinctive of trademarks is what we call fanciful. It's basically a made up word, right? So the more ridiculous it sounds, the better. Remember, this is the Patent and Trademark Office. The Trademark Office wants you to invent words. They want you to coin phrases. They want you, the more ridiculous it sounds, the better. The chances are that nobody's ever heard it before. So this is the type of trademark that gives you the broadest protection possible, because anybody that comes after you, you'll be the first. Anybody that comes after you, you'll have not much to prove, right? There's no way they could have conceived it unless they got it from you. And even if they didn't get it from you, you were first and you have it there. And so, it's really important to kind of think outside the box and be more creative and really kind of create a great trademark. I know this is hard. And I know that, there are companies that, spend like millions of dollars trying to create the most perfect trademark out there. I don't think you have to do that, right? But, kind of think about different things like mashing words together, thinking about how your consumers will feel, maybe use that as the trademark. Just think about things that are not descriptive of the product or the good that you're selling. That's probably the three best rules that you don't have to, hire $1 million advertising agency to figure out a word or a logo that is truly distinctive. But the more, I kind of put this slide up there to let you know that the more money you spend on developing your trademark, right? Because if you want to coin a term, you're going to have to teach the world what it is. It's inversely related to the amount of money you'll spend on protecting it, on enforcing it against others. So you may spend no money on using a generic or descriptive word. There's no market. There's nothing there. There's not, you didn't really come up with anything. You didn't do anything. You're not teaching anything to anybody. So you're not spending anything. But you'll spend a lot of money to stop someone else. You not only will spend a lot of money trying to stop someone from using your generic or descriptive word, but you're probably going to fail at it also because of the fact that it's not even protectable. So spend more money up front on a good brand. You'll spend less money enforcing it. Very quickly, there are a few ways to file for a trademark. There are words and logos, right? There's a few other types of trademarks we'll get to in a second, but the majority is a word like Nike, Google, Goggle. But there's also logos like the Target bullseye or the Nike swoosh. Those are separate filings. And the reason why we like to keep them separate is because if you want the ability as a company to play with placement, right? If you want your Nike to be on top of your swoosh, then best to file them separately and you can do whatever you want with them. Because if you filed your Nike on top of your swoosh, then that will be your protection. And then if you decide to change up that placement, like if you decide to put the Nike under the swoosh, well, your trademark application is the Nike above the swoosh. And so that's not good because your placement mattered, because that's how you described your mark to the trademark office. So in the end, what we say is file them separately so that you can play with them, individually and together afterwards. Most companies, if they have the budget, they file a lot of permutations. They file in black and white, they file in different colors, they file, words, they file slogans, but it's all budget related at the end of the day. But no matter whatever you file, you must actually prove eventually that you're using it in the way that you say you're using it. So you can't, if you look at a company like Bed Bath & Beyond or Target or Walmart, they have hundreds of applications from a defensive point of view, but they are using all of them. Make no mistake. You may not see them all, but somewhere they're using some of them, whether it's different colors, different placements, and that's because they have to in order to maintain the registration. So the question, the last thing I'll say about trademarks, and then we'll take questions, and then we'll go very quickly to copyright, is I said before, it's all about the 5 senses. So let's take Red Bull. They have protection on Red Bull, REDBULL, a word mark. They have logo protection on the bulls that are trying to ram up against each other. They have protection of the colors, how the actual, gray and blue kind of meet in triangles. But they also have protection for the can, right? The shape of the can is dressed in their trademarks. And if you can, do that, you can get protection over a shape. So like Lego, if you look at a little Lego piece, what's on top of the Lego head is a little logo, right? Lego. So Lego has protection over their figurines, right? Because their trademark is dressed on their products. Apple has protection for the layout of their store because the Apple logo is dressed all over the store. So this is great protection for products, for foods, for services, for computer graphics, for images. There's a lot of cool stuff that you can do with trade dress protection. It's definitely thinking out of the box. So again, if you appeal to the 5 senses, there's likely something that you can protect if you can, brand it with a trademark. Okay, questions on trademarks. What is this?
So David, there's a few.
Yeah, I see. Okay, can I register a 2-word name instead of a logo? Yes, of course. You can. I have people that register slogans, right, with like 10 words in it and stuff like that. You'll have to prove that you're using that word, those 2 words. In like if you're using 2 words on like a phone case, make sure both of those words are legible on the phone case in order for you to get the trademark. So Becky, I don't even know if you're still on the call. I think
She's not.
She's not. It's a good question, but sorry, you're not on the call. That's punishment for not being on the call. Our watermarks, no, hold on. Nick the Brit. Yes, Nick, if you are using that trademark to sell goods or services, then you should probably file for that name for sure. Just keep in mind that names are generic, right? So you may not get Nick, but you'll probably get the Brit if there's not another similar trademark out there. Are watermarks on photos worthless prior to filing for a trademark? Okay, that is a good question, Lakia, but it has nothing to do with trademarks. Watermarks is everything to do with proving you created a particular photo, right, or work. That's for copyright, and we're going to get to that in a second. So we'll come back to that again. So what you wouldn't file a photo. Are watermarks on photo? Yes, I'm not sure what you mean there, but basically, Lakia, if your watermark is your logo, right, and you're using it for other purposes other than putting it as a watermark on your photo, like you're using it to sell something else, then of course you should file for a trademark application on that. but a watermark on a photo is mostly used to prove that you created the photo itself, right? So, a single photo is not protectable by trademark. It'd have to be like, that would have to be your business, right? You'd have to be a photographer type of thing. The service would be the actual photo, if that makes sense. I'm happy to talk about that later. What are the dangers of filing by ourselves? Good question. I'll say this. I hope it doesn't come off too sarcastic or facetious in any way, but I think you'll catch the gist of what I'm trying to say. Patents and trademarks are an area of law with a lot of peculiarities, and it could be complex. It could be simply complex, right? That type of thing, right? And so there are things that you can do on your own that may cause issues for us, like may cause issues for you that we may not be able to get you out of, that you come to us afterwards with. You know what I'm saying? You can file by yourself and then you realize that you're up shit's creek, and then you come to an attorney and there's not much we can do for you. So I often say to people like, listen, I would not go to my dentist to get a haircut. I wouldn't go to my, I wouldn't ask my, dentist to perform brain surgery on me, like things like that. It's just the same thing. That's how professional we are and take this. This is something that we know the intricacies of. That's our job, is to, prove on your behalf that your patent and trademark is novel and distinct. And so there are a lot of dangers in doing it by yourself. Filing wrong, filing incorrectly, filing in a way that statutorily blocks you from ever trying to fix it, increasing your costs. Here you are, a lot of people file themselves because they don't want to pay, like this is typical, right? They don't want to pay a lawyer. So I'm going to file by myself and I'm going to spend $350. And boom, I hit a roadblock, and now I got to go back to the lawyer and I'm going to spend triple, right? Because I have to. So like, probably should have spent double, right? Okay, so maybe wouldn't charge you $350 like you would have spent. We'll charge you $700, right? So you pay double, but at least you won't have to pay triple in the future. So, yeah, I'm not so sure. It's definitely a process with the government. Anything with the government, kind of should involve a professional if possible. Thanks, Nick. Is there any disclosure time restrictions on trademarks? Meaning, it's a good question. Meaning, is it similar to patents where I cannot have exposed the trademark to the public for a certain? No. So, Lakia, you can have an unregistered trademark, as we talked about before. But there's some danger in that. I have a client that had a trademark for 20 years. They never filed for it, and then finally, 20 years later, she finally comes to us and says, "I want to file now." Okay, we're gonna file now. Lo and behold, somebody 2 years prior to her, who only had a business for 3 years, she had a business for 17 more years than this guy, filed for the exact same trademark 2 years before her. The exact same trademark, doing the exact same thing, photography. So that was a huge risk, because now to be perfectly honest, we couldn't get it. You know how hard it is to prove to the trademark office that two exact words doing the exact same things are different from each other? No, that doesn't work, right? There's no differences. There's no differences in word. There's no differences in services. So the person that's been around only for 3 years, that is only, and you've been around for 17, they win. They're first to file. So it's tough. So you should not expose your trademark. You should try to only expose your trademark after filing a trademark application. Ideally, that's what you should do. You do not have to set up an LLC prior to register a trademark or a patent. Patents can be filed in inventor names. Trademark can be filed in as an individual, and you could assign it later to whatever company that you want it to be owned by. Okay.
David,
good questions on trademarks. Yes.
One more question. Where does the TM go, and are there other versions of the TM?
Yeah. What is a TM exactly? The TM is basically used under two circumstances. One, I intend to file for my trademark, meaning like that situation where the person that I told you that didn't file for their trademark for 20 years, she was able to use a TM. Her intent was always to file a trademark. She just never got around to it. And then it bit her in the ass, but she can use a TM, right? A TM doesn't mean, it means that, meaning I intend to file. So use it on everything, whether it's protected or not, use it. But also a TM signifies that I may have a trademark application on file and it's just not registered to me yet, right? So you have to almost like, so TM is good, but really what we covet is the circle R. You can only use the circle R, the registered trademark symbol, once you've been examined and awarded a trademark. If you use the circle R when you haven't been awarded a trademark, it's considered false marking, and it's illegal basically under the law. There's like, it's like a civil, violation. So it's not good. It's not criminal, but in some countries it's criminal, but in the United States it's civil. But it's still an infraction that comes with damages and stuff like that. So yeah, everybody should use a TM whether you file or not. Yeah, again, you do not have to know, you don't have to have an LLC to file for a trademark. You can file it in the name of an individual. Like Emily can file a trademark in Emily's name today. And if Emily then decides to transfer the trademark to her LLC 3 years from now, great, she can do that. It's called an assignment. Basically, Emily will sign an agreement saying that I, Emily, now assign the full rights of my trademark to an LLC. Same thing for a patent. I am the inventor, Jason, I'm the inventor, and it's in my name, and now I want my company to own it. So I'm going to assign it to my company. That's how it's property. So you can assign it and transfer ownership very freely, right? Just like property, you can take the deed to your house and you can assign it to your children or something like that. So just like a piece of property. So yeah, that could be done at any time. Okay. Last but certainly not least, copyrights. Probably the simplest of intellectual property rights to obtain, but one of the most contentious out there. Unbelievable how contentious copyrights is, and you'll understand why in a second. Copyrights are the artistic expressions that come from your intellect that you need to physically embody in something, and then register that with the Copyright Office. So if I write a song, I put it on a piece of paper and I send that to the Copyright Office and they register the copyright to me. I take a picture, I paint, right? The medium is the canvas. The medium is the actual digital photograph. It's the website pictures, it's the app pictures, it's software code, it's music, it's choreography, it's all of those things. You basically take those things and you file it with the Copyright Office, and you get the ability to control 5 things related to what you created: the copying, distribution, displaying, performing, and the right to control whether somebody takes a piece of it and creates another work. It's excellent protection. It's the only form of intellectual property that is automatic. The moment you create, the moment you put pen to paper, the moment you snap the picture, the moment you literally sit down as a developer and type out code for software, you are the creator. It is your copyright. However, what doesn't happen with a copyright that happens with a patent and trademark is a copyright does not get examined. Right? A patent gets examined and awarded to you. A trademark gets examined and awarded to you. A copyright does not. There are, tens of millions of copyrights on file with the Copyright Office. There is no time, there is no procedure for them to say, okay, I see that you wrote a poem, and now I'm going to compare that poem to the 9 other million poems that have been filed as copyrights, and to determine that you were the original author of that poem. It just doesn't happen. So that's why it's the most contentious. You may think that you are the creator of an original work, but it could possibly be that somebody has filed something similar before you and created something similar before you. So we often say the moment you create something, you need to register your copyright. If you want to wait 20 years to register your copyright, then the chances of somebody creating something before you or potentially filing a copyright before you are really high. And if they're on file with their copyright registration before you, then it's evidence that they possibly created it before you, even though they probably didn't. How are you going to prove that you did? So your creation date is linked to your copyright registration date, which is why take it out of automaticness and file for the copyright. It's about $465 to file for a copyright if you use a lawyer. The actual fee is only $65. And a copyright will last, like, remember, a patent expires after 20 years. A trademark is renewable every 10 years. The copyright registration will last your entire life. Then you die, and then it lasts 70 years after that. So it lasts a really, really long time. So it's great protection. It's also the only type of intellectual property where you can use the Circle C, right? The Circle R is like, no, you cannot use that until it's registered. But the Circle C, you can use whether you registered the copyright or not, right? To put people on notice that you've created it and the year that you created it, right? You've seen at the bottom, right? The Circle C, the year of creation and who owns it, whether it's a company or an individual. So you can protect a lot of things in copyright: literary works, visual arts, sound recording, audio-visual works. Actually, I think I stopped there because it was so much, but I'll tell you one more thing and then we'll do final questions. Copyright is the one thing I need you to understand about copyright is that if you are not the creator, let's say you hire someone, or let's say you ask a friend to create something for you. It happens all the time, right? Create my logo, create my website, do a favor for me. You have to understand, under the law in the United States, the person that creates is the owner of the copyright. So if you are asking someone to do something for you artistically, they are technically the creator and they are technically the owner of the copyright. The only way the copyright will transfer to you, you want it, right? You're asking them to do it for you. You're paying them to do it for you, right? You're getting a favor, you're paying, whatever the situation is. The only way it's going to transfer from them as the creator to you as the owner is through an agreement called a work made for hire. There must be an obligation, an assumption by that creator that they understand that they are giving up these 5 rights, that they are giving up their right of copy, distribution, derivative work, displaying, performing. If you don't have that in writing, then it's possible that you do not own the copyright to what you've created. And that could only be disastrous later on. So get a work made for hire. I get it. We all have friends, family that do favors for us. I don't care. I'm not saying you have to charge them money to do it, but a simple agreement that says it is mine. I get to do now. I get to do those 5 things: copying, distribute. I get to control what happens with the creative work that you're creating for me. Without that, it's possible it will not transfer to you. So that's it. That's everything. And again, this is just the tip of the iceberg. I'm happy to talk about some of this in detail if you have questions later, or if you have questions now, if we have a few minutes for questions now. What do you think? I show website copyright by me and my client. Is that okay? What do you mean, Nick? Can you get off mic? Can you go on mute and just let me know what you mean? Do you mean that you write in the copyright?
At the bottom of the screen, at the bottom of their website, I put copyright by my company name and their name. So I've got them both showing.
Yeah, I mean, that's fine, but I guess you must have an agreement somewhere where you're both the owners of the website, right?
It's what I've always done since I've been doing web hosting.
Yeah, I mean, that's okay. I mean, if your client doesn't mind, fine. But it definitely, like, if yeah, I guess that doesn't matter. I mean, you didn't create it for them, right? You're just hosting it for them, right?
No, I created the sites.
So by you creating it for them, and you don't have an agreement between you and your client saying that they own the website, the copy on the website?
Well, yeah, basically I'm saying, my clients have been happy with it. I've been doing it for about 20 years of website development as well as hosting, but I show that it's both our copyrights just to protect us both, basically.
Yeah, that's fine. That's fine. Yeah. But you should register it that way. You should, like, part of your engagement process with your clients should be to periodically have the client file a copyright registration under both of your names, because if you ever if somebody cloned your site, which happens all the time, and started coming up with a competing business, the only way you're going to be able to take them down, like through what we call like a DMCA takedown, a Digital Millennium Copyright Act takedown, where you let your internet service provider know, like, hey, somebody's cloning me, somebody's infringing my website, somebody's copying my website. The only way you're really going to get anything to happen is if you have a copyright registration. So yes, I get you're doing it for 20 years, but like, it's such a simple step. Why not do it to show that, to confirm the copyright notice is what I'm trying to say. Get the registration to confirm the copyright notice that you're putting in.
Well, I would probably do it only if a client says, "Are we really registered copyright?" So I would then suggest what you suggest.
Yeah, I got it. A group came up with a specific logo and design. Should the group, not a well-funded one, try for copyright or trademark? Emily, the answer is very simple. If you are going to use that logo in commerce, right? You're going to use the logo to sell a good or service, then it's trademark, right? They're not mutually exclusive. You can be both. But the rule for trademarks is you're only going to get it if you're using it to sell a good or a service. If you're not, and which I can't even imagine why then you would create one, but let's say you weren't and you just kind of created one because you're not sure what to do with it yet, then for sure you should be filing for a copyright on that original design, right? Because it's like a skull, it's like what we call visual art, right? It's like you're creating or you're designing something on paper. Yeah, so you might need both, is what I'm trying to say, if you're selling this good or the service. Yeah. Cool. Other questions before we end? This is me, by the way. If you want my email at the bottom, happy to.
Dave, you want to put your email in the chat?
Yeah, let me do that. Hold on. I'll stop share too. Hold on.
And we're going to be emailing, with David's permission, we're going to be emailing all the attendees a copy of today's session. So if you had a question, David maybe went over something, you don't recall the answer, you'll be able to refer back to that.
Yeah, totally. Are there any students left on the call, by the way? Just curious.
Yes, at least Judy. I'm not sure about Adrian or Crystal or Chris. I don't know.
Yes, I'm a student. I'm Crystal.
Okay, I don't know if you want to. Hey, Adrian, also, I don't know if you're Judy or Crystal or whatever, if you want to, kind of talk afterwards, I'm happy to, because of the pitch competition, maybe we kind of book some time afterwards, just if you have specific questions about your specific pitch. I'm happy to do that.
Yeah, that'd be great.
Great. Lakia has some really good questions, actually. Let me just, she has some good ones. Do you actually, it's a good question. Do you actually own a logo made on a site like Canva? So Canva's like 99 Designs, it's like Fiverr, stuff like that. Very, very controversial stuff. You need to look, the answer is probably you own it, right? I don't want to put those sites down. Likely you own it, but what you really need to do, Lakia, is because I don't know anything about Canva, but I know Fiverr and I know 99 Designs. And I know they've been specifically involved in disputes when they first came out that caused them to amend their terms of use and service. So just take a look at Canva's terms of use and service, the terms, the terms and conditions, the stuff like that, and just see who owns what, who owns what, and who, what, where, when. Just take a read. There are definitely some apps where you may own it, but the person, the company or the graphic designer also owns it or has some residual rights to it, under certain circumstances. So just kind of confirm that and read that before you get involved in something like that. Good question though. Cool. I think we're done. Okay.
David,
Thanks.
I want to thank you. Oh, did somebody have a question?
Yeah, sorry, it's me.
Oh, hi.
Hi. Sorry about that. I was eating my lunch. That's why I had my camera off. I just wanted to know, is there a template or something that we can look up for like the work made for hire or the non-disclosure agreement?
Send me an email. There are agreements I give away for free. That's how important they are, right? I think you get how important a work made for hire is or an NDA is just based on the presentation. Send me an email. I'm happy to send, it's not really a template, but something that you can use, kind of going forward to satisfy, most situations. Yeah, send me a quick email.
Okay, great. Thank you.